it's my personal philosophy, and I'm not speaking for anyone other than for my own personal views. But I have, in most circumstances, I have favored having open courts. I believe that people need to know what is happening in these courtrooms. But I also support a system by which the judge maintains the discretion to make exceptions in order not to traumatize a child. While we need to balance the need of the public to know, as a juvenile judge, for me, paramount is what's in the best interest of that child. And not all of the time is having the public in the courtroom, is it in the best interest of that child. However, there are proceedings which are more routine, but nevertheless, there's a lot of information that I think the public should see and hear.
Like what?
Well, for example, not the majority of the cases don't result in a contested hearing or a trial, but you get to see how all of the people involved work in a collaborative manner, where the parents recognize that they need help and that they need to address their drug dependency. They need to address whatever brought them to the juvenile court, and that the social workers, the lawyers, everyone has created a plan. The parents have bought into the plan, are working, and we are encouraging them. I am making sure that the services that we said they needed are being provided, so that as I'm steering this big ship, I am seeing firsthand that where there may be a breakdown, where there may be a mix-up in communication, and at the same time it creates an environment for people to see that that I feel people are getting a fair shake, that it isn't an oppressive environment, that we truly do try to do what's in the best interest of the families, within the guidelines and mandates of the law. So that I think that if more people saw how the juvenile courts operate, I think it would demystify these closed courts. I think people would have a better understanding. I think perhaps even, the decision makers would see how important it is for funding to continue and to increase in these types of courts.
Yeah, definitely. You said opening it up to the media. Is there, I think media is becoming more and more fuzzy, right? Because you have some people who are bloggers or citizen journalists, and maybe they don't work for a traditional news station or a newspaper. Are there types of journalists if the courts were open that you would not want to be able to attend, or do you think anyone should be able to? It should be open to anyone?
Well,
or?
I think the discussion has been for anyone, just like a criminal court is open to anyone,
Mm-hmm.
a family court is open to anyone. Now, there's still restrictions as to how you can record
Mm-hmm.
the information that is happening.
Mm-hmm.
I have had in juvenile court some people, not necessarily from the media, the press, but community members that want to observe, what is happening, and with the consent of the parties, they've been allowed to sit in and observe, so that obviously how that information is being disseminated is very important. I see children that feel uncomfortable just even being in a courtroom where only the lawyers and the judge, are present. And so that to add other people, people that may now be putting the face of this child, the circumstances of their, being in court on Facebook or one of those other media, sites, could be very traumatic. We go through great lengths to make these children feel normal. And that's a request that I get from them. Judge, I want to be normal. So when the social worker goes to the school, don't have them pull me out of school. Don't have them come to school with marked cars that will flag me as, I'm not normal because I'm a foster child. We go to great lengths to ensure that they stay in their school of origin, that all of the documentation, even among other governmental agencies, they cannot just come and look at our records. There are many cases where the parents are also facing criminal charges. But that doesn't mean that the district attorney or the defense lawyer can just come and look at our records. There's specific processes they have to take before even they can access the information. So I think that the overall premise of opening the courts, I think it's good. The how, as they say, the devil's in the details.
Definitely. And my last question, do you think there should be some kind of code of ethics or something that people sign if it is opened, so that they don't, to kind of help protect how that information is disseminated like you were talking about?
Well, there's definitely has to be, from an ethical, a legal, and perhaps even a moral perspective, that we have to ensure that this information is going to be used for the ultimate purpose that I think perhaps society in general wants to be able to access. We don't want, and I know this is an extreme case, but for pedophilic to now be accessing, the face and name, the details. And remember that a lot of these children are there because they've been sexually molested, right? So that every time that the issue comes up, they run the risk of being traumatized again. And so, yes, I do see that the courts would have to be very vigilant that these children who are, and we have to remember, these children are there through no fault of their own. They're there oftentimes because of the sins of their parents. And so, unlike with the delinquency courts, where the child was involved in some mischievous act or at least accused of, dependency courts, child welfare cases, are children that have been abused and neglected. And so that I feel very strongly that we need to make sure that they're protected from further trauma, further injury.